My name is Renee Calloway, and the first time I found out my sister had filed for emergency guardianship over our father, I found out from a sheriff's deputy handing me paperwork on my own front porch. That was the first shock. Here's the second, and it came about 90 minutes later, sitting in a county courtroom I'd had less than 2 days to prepare for. My sister Yvonne stood up in front of a judge, put her hand over her heart like she was about to recite something sacred, and said, "Your Honor, I've been the only one showing up for my father for the last 8 months. My sister abandoned him the moment things got hard." 8 months. That number landed in my chest like a fist, because I could tell you, almost to the day, how many times I had driven 3 hours each way to sit in a hospital room holding our father's hand while machines beeped around him. I could have told that judge the exact date of his stroke, March 3rd, and the exact number of weekends since then that I hadn't shown up, which was 0. Not one, not a single weekend. But I didn't get to say any of that yet, because Yvonne's attorney was already moving to the next part of her petition. Temporary emergency guardianship, granted on the basis that our father, William Calloway, 71 years old, was medically incapacitated following his stroke, and that Yvonne, as the consistently present and responsible adult child, should be granted authority over his medical decisions, his finances, and his home, effective immediately, pending a full hearing in 90 days. The judge granted it, temporarily, right there in about 11 minutes, based almost entirely on my sister's word and a doctor's letter confirming Dad's incapacity, a letter that said nothing at all about which of his daughters had or hadn't been showing up. I sat in that courtroom in jeans and a wrinkled blazer I'd grabbed in a panic that morning, and I felt something crack open in my chest that had nothing to do with grief over my father's stroke, and everything to do with the specific, deliberate unfairness of watching my sister lie under oath and get rewarded for it within the hour. Before I go further, tell me where you're watching from tonight and what the weather's like where you are. I always read the comments, and tonight's story took me almost 9 months to actually resolve, so settle in. I want to be honest about something right away. I didn't leave that courtroom plotting revenge. I left it in shock, mostly, driving home with my hands shaking on the steering wheel, replaying every single visit, every missed birthday party of my own daughter's that I'd skipped to be at that hospital instead, wondering how my own sister could stand in front of a judge and erase 8 months of my life like it had never happened. It wasn't until I got home and opened my phone's photo app, out of some instinct to find proof, any proof, that I existed in my father's hospital room, that I found the first hard evidence that Yvonne's story wasn't just an exaggeration. It was a calculated, specific lie, and the hospital's own records were about to prove it. To understand how deep this went, you should understand a little about our family before the stroke. Our father, William, spent 31 years as a machinist at a manufacturing plant outside Dayton, Ohio, and never made more than about $68,000 a year in his life. But he was careful, almost obsessively so, about saving. He and our mother, who passed away 9 years ago from ovarian cancer, bought their house in 1989 for $61,000, paid it off in full by 2011, and by the time of his stroke, Dad had roughly $340,000 in retirement accounts and savings, plus a house worth around $215,000 in the current market. Not wealthy by any stretch, but by the standards of our working-class family, it was a genuinely significant estate, the kind of money that could mean the difference between a comfortable retirement community and struggling, depending on who controlled it and how. I moved 3 hours away to Columbus for a logistics coordinator job 11 years ago, married my husband Tomas there, and had our daughter B, who's now 7. Yvonne stayed in Dayton, 5 minutes from Dad's house, and for most of our adult lives, that proximity meant Yvonne handled the small, regular things, mowing his lawn, driving him to routine doctor's appointments, the kind of steady, unglamorous care that doesn't show up in dramatic stories but genuinely matters. I want to say clearly, before all of this, I respected that. I sent money regularly to help cover costs, usually $400 to $600 a month, sometimes more, specifically because I knew Yvonne was doing more of the physical, day-to-day work simply by being closer. What I didn't know, and wouldn't find out until much later, was that Yvonne's husband, Marcus, had lost his real estate brokerage license 18 months before Dad's stroke, following a dispute with a former client that resulted in a $47,000 civil judgment against him, a debt Marcus had never fully disclosed to Yvonne's own family, let alone mine. and that had put the two of them under mounting financial pressure I had absolutely no visibility into. When Dad had his stroke on March 3rd, I was on a plane to Dayton within 6 hours of getting the call. I stayed in a hotel near the hospital for the first 11 days, working remotely from a Marriott lobby so I could be at his bedside every evening, before eventually settling into a pattern. Driving down every single Friday after work, staying through Sunday, and using every available day off from my job, eventually exhausting almost all of my paid time off for the year, to cover longer stretches during his acute recovery phase and the rehab facility placement that followed. Yvonne, for her part, visited regularly too, especially in the first few weeks. I'm not telling you she abandoned him, that would be its own kind of lie, just pointed in a different direction. What I'm telling you is that by the time she stood up in that courtroom and said she'd been the only one showing up, something had already shifted in how she was framing the last 8 months, in a way that had nothing to do with what had actually happened and everything to do with what she needed a judge to believe. That first night after the hearing, I went through my phone and found 11 months of photos, dated, geotagged, sitting right there in my camera roll. Me and Dad doing his prescribed hand exercises in the rehab facility. Me pushing his wheelchair down a hallway with a hand-lettered "Happy Birthday Dad" balloon tied to the armrest, from a small birthday celebration I'd organized in June. A blurry selfie of the two of us on a Sunday afternoon in August, him managing a lopsided but genuine smile, the stroke's effects on the left side of his face still visible but improving. Photos are evidence of presence, but I knew, even in that first panicked night, that photos alone weren't going to be enough to unwind a court order. A judge could reasonably say photos show visits happened, sure, but they don't establish a pattern, they don't establish who provided actual day-to-day care. And this was the part that scared me most. They definitely didn't establish who was managing Dad's finances, which was the part of the guardianship that actually mattered most in practical terms. I called my husband Tomas from the hotel room I'd booked for the night, too rattled to make the 3-hour drive home. He's an accountant, methodical in a way I am not, and he asked me the question that ended up shaping everything that came next. Does the hospital keep visitor logs? I didn't know. I'd never had a reason to think about it. But it made immediate sense. Most hospitals, especially during and after COVID-era protocols that a lot of facilities never fully abandoned, required visitors to sign in at a front desk or badge in through a digital kiosk, logging name, date, and time. If that system existed at Dayton Memorial, where Dad had been treated, there would be an actual, time-stamped, third-party record of exactly who visited. And when a record that had nothing to do with my memory or my sister's, and everything to do with what a computer system had logged in real time. I called the hospital's medical records department first thing the next morning. It took 4 phone calls and eventually a formal written request. Dad, still cognitively present enough post-stroke to consent, though his speech remained affected, signed a HIPAA release allowing the records to be shared with me, but 11 days later I had it. A printed visitor log spanning March 3rd through the date of the courtroom hearing. It showed 47 separate visitor sign-ins under my name. It showed 31 under Yvonne's. That gap, 47 versus 31, wasn't damning on its own. Nobody was claiming Yvonne had visited 0 times, but it flatly contradicted I've been the only one showing up, and more importantly, it gave me my first piece of hard, institutional, third-party evidence. Not my word against hers, but a hospital's own record system against her sworn courtroom testimony. If you've ever had to prove something obvious using paperwork nobody normally thinks to save, a receipt, a log, a timestamp, tell me about it in the comments. It's wild how often the truth ends up sitting quietly in a system nobody thought to check. The visitor log was a start, but it wasn't going to be enough by itself to reverse a guardianship order, and I still didn't understand yet why Yvonne needed that guardianship badly enough to lie under oath to get it. That answer was still weeks away. I hired an elder law attorney named Priyanka Desai 8 days after the hearing, on the recommendation of a coworker whose own mother had gone through a contested guardianship years earlier. Priyanka's retainer was $3,500, which felt like an enormous amount of money to spend based on a hunch and a visitor log. But Tomas didn't hesitate, and honestly, neither did I, not really, not once I let myself sit with what was actually at stake, which wasn't just money. It was our father's autonomy at a moment when he was vulnerable and recovering and couldn't fully advocate for himself. Priyanka's first move wasn't dramatic. She explained patiently that temporary emergency guardianship orders are usually granted quickly, and with a relatively low evidentiary bar specifically because they're meant to be temporary, a stopgap to prevent immediate harm while a full hearing gets scheduled. The real fight, she told me, would happen at the 90-day full hearing, and between now and then, my job was to build a complete, methodical, undeniable record, not just of my own presence, but of how Yvonne was actually using the guardianship authority she'd already been granted. That second part turned out to matter enormously. Priyanka filed a formal request for an accounting of guardianship expenditures, a legal mechanism that requires a guardian managing someone's finances to periodically report exactly what they've spent and why. Yvonne, now in control of Dad's bank accounts under the temporary order, was legally required to account for withdrawals. The first accounting report came back 5 weeks later, and it was vague in a way that immediately raised flags for Priyanka. Broad categories like medical expenses and home maintenance, covering withdrawals that, added together, came to just over $61,000 in the first 2 months of guardianship alone. For context, Dad's actual out-of-pocket medical costs during that window, based on the insurance explanation of benefits statements I was able to obtain separately, came to roughly $8,200. $53,000 unaccounted for in 2 months from a man who couldn't yet fully speak for himself. I remember sitting across from Priyanka's desk when she walked me through the numbers and feeling something shift from grief and confusion into something colder and more focused. This wasn't about a sister exaggerating her own contributions out of hurt feelings or sibling rivalry anymore. This was starting to look like money was moving somewhere it shouldn't be, under legal cover that my sister had obtained in part by lying about my absence. "We need bank statements," Priyanka said. "Not summaries, actual statements transaction by transaction." It took another court motion. Yvonne's attorney resisted, calling it harassing and unnecessary, but a judge reviewing the vague accounting report agreed the specificity was warranted. 6 weeks after the original hearing, I finally had Dad's actual bank statements in hand. The transaction history told a story that had nothing to do with medical bills. There was a $22,000 wire transfer dated April 19th, sent to an account belonging to Marcus Reyes, my sister's husband. The memo line, visible on the bank statement, read, "Loan repayment." I didn't know Dad had ever loaned Marcus $22,000. As far as I knew, before all of this, Dad had loaned exactly nobody in our family any significant sum in his life. He was famously, almost stubbornly averse to lending money, even to his own kids, on the grounds that money and family shouldn't mix. I'd heard him say that sentence probably 24 times growing up. There was also a payment of $9,400 to a company called Brightpath Home Solutions, dated May 2nd, for what the invoice, which Priyanka's office subpoenaed directly, described as kitchen renovation consulting and design services. Dad's house had a small, dated but entirely functional kitchen that, as far as I knew, nobody had discussed renovating. I called the number listed for Brightpath Home Solutions myself out of simple curiosity, and reached a voicemail box that had clearly not been checked in some time. When Priyanka's investigator dug further, Brightpath turned out to be a business registered under Marcus's name 6 weeks after Dad's stroke, an LLC with no other clients, no other invoices, and an address that traced back to Yvonne and Marcus's own home. Then there was the pattern that, once I saw it laid out in a spreadsheet Priyanka's paralegal built for us, made my stomach turn. A series of 11 separate cash withdrawals, each just under $10,000, specifically structured, it seemed, to stay under the $10,000 threshold that triggers automatic federal reporting requirements for banks. Combined, those 11 withdrawals totaled $97,300. Between the wire transfer, the fake consulting invoice, and the structured cash withdrawals, roughly $128,700 had left our father's accounts in the first 4 months of the guardianship, nearly 40% of his entire savings, with no connection to his actual medical care, his actual home, or his actual well-being that anyone could identify. I confronted Yvonne on the phone that same evening, the first real conversation we'd had since the courtroom. She didn't deny the transfers existed. What she said instead was, "Dad wanted to help us. Marcus is his son-in-law." family helps family. Did Dad actually say that, or did you decide that on his behalf? Silence on the line, long enough that I knew the answer before she found words for it. While Priyanka and I were unraveling the bank statements, something else surfaced that reframed the entire timeline. A durable power of attorney document, signed by our father, dated March 9th, 6 days after his stroke, while he was still an inpatient at Dayton Memorial, before he'd even been transferred to the rehab facility. I hadn't known this document existed until Yvonne's attorney referenced it in a filing, arguing it demonstrated Dad's own clearly expressed wishes regarding who should manage his affairs, as if a 6 days post-stroke signature settled the entire question of guardianship on its own. Priyanka's reaction to the document's date was immediate and sharp. 6 days after a stroke, she said, with no documented capacity evaluation on file, is exactly the kind of timing that gets power of attorney documents challenged and thrown out. She requested Dad's full medical chart from that specific window, March 3rd through March 12th, and what came back was, to me, devastating in a very specific way. The chart showed that on March 9th, the same day the power of attorney was allegedly signed, Dad's medication record listed a scheduled dose of a sedating pain medication administered at 9:15 a.m. A nursing note timestamped 9:40 a.m. described him as drowsy, intermittently oriented, difficulty forming complete sentences. The power of attorney document itself, notarized in the hospital room, was signed and stamped at 10:05 a.m. 25 minutes after that nursing note, there was no formal capacity evaluation on file. No note from an attending physician confirming Dad understood what he was signing. Just a notary, a mobile notary service Marcus had apparently arranged and paid for directly, records later showed, who'd come to the hospital room, watched Dad make a shaky signature and stamped the document as valid. I want to pause here and say something important. I don't believe my father in a clearer moment would have wanted this outcome. I don't believe, even now, that he consciously understood what he was agreeing to on March 9th. What I believe, and what the medical timeline strongly suggested, is that Yvonne and Marcus, whether out of genuine desperation about their own finances or a colder, more calculated opportunism, or some tangled mix of both, moved to formalize control over Dad's affairs at the earliest, most vulnerable possible moment, while he was too medicated and disoriented to meaningfully understand or resist what was happening. Priyanka filed a motion to invalidate the power of attorney on grounds of lack of capacity, supported by the medical chart timeline. That motion alone took another 6 weeks to be heard. I wanted to understand the full financial pressure Yvonne and Marcus were under, not because it would excuse anything, but because I needed to know what I was actually dealing with, a desperate, cornered couple making a series of increasingly bad decisions, or something colder. Public court records made most of it findable. The $47,000 civil judgment against Marcus from the real estate dispute was a matter of public record, and it turned out that wasn't the whole picture. There was also a second, smaller judgment, about $11,000 from an unrelated contractor dispute at a rental property Marcus and Yvonne owned together, plus a notice of mortgage delinquency filed against their own home 4 months before Dad's stroke, indicating they were roughly $14,000 behind on their own mortgage payments at the time. Altogether, Marcus and Yvonne were looking at somewhere around $72,000 in documented debt and delinquency before Dad's stroke ever happened. A number that lined up disturbingly well with the pace and size of the withdrawals that started flowing out of Dad's accounts within weeks of the guardianship being granted. I don't say this to paint my sister as a mustache-twirling villain, because that's not who she is, and it's not the honest version of this story. Yvonne, I came to understand over the following months, had spent years watching Marcus's real estate career slowly collapse, quietly covering gaps in their household finances, deeply afraid of the shame of losing their house, of having to explain to her own kids, my niece and nephew, ages 9 and 12, why they might need to move. When our father's stroke created an opportunity, framed by fear and financial panic rather than any careful long-term scheme, she took it. That doesn't excuse the lies she told in that courtroom or the withdrawals or the fake invoices, but it explains them in a way that's more human and honestly sadder than simple greed. I asked Priyanka, at one point, whether any of this made me a bad person for pursuing it as far as I was pursuing it, for essentially building a legal case against my own sister during what should have been a season of the family pulling together for our father's recovery. She told me something I've held on to since. You're not doing this instead of caring for your father, you're doing this because you care for him. Those aren't in conflict, even when they feel like they are. The full guardianship hearing happened just over 90 days after the original emergency order, as scheduled. By then, Priyanka and I had assembled a case file that included the hospital visitor logs, the bank statements showing the $128,700 in questionable transfers, the fake BrightPath invoice with its traced LLC registration, the medical chart timeline undermining the power of attorney's validity, and this was new. And it mattered more than I expected, a court-appointed guardian ad litem's independent evaluation. I hadn't fully understood, going into this process, that in contested guardianship cases, courts frequently appoint an independent guardian ad litem, a neutral third party, usually an attorney, whose only job is to investigate the situation and report back to the judge on what's actually in the incapacitated person's best interest, separate from what either family faction is arguing. Our court-appointed guardian ad litem, a woman named Colette Whitfield, interviewed Dad directly, twice, by that point communicating well enough. His speech had continued improving steadily through months of rehab. To answer straightforward questions clearly, even if longer, more complex conversations still tired him quickly. She also interviewed me, interviewed Yvonne, reviewed the medical chart, reviewed the bank statements, and toured Dad's home, which, this detail came out during her report, had seen no actual renovation work despite the $9,400 kitchen renovation consulting invoice. No contractor had ever set foot in that kitchen. Colette's written report to the court was thorough and, for Yvonne, devastating. It documented the visitor log discrepancy contradicting her sworn testimony. It documented the unexplained financial transfers. It noted that Dad, in his own words during their interview, said he did not recall clearly agreeing to a kitchen project, did not recall discussing a $22,000 loan repayment to Marcus. And this was the sentence I read probably a dozen times after receiving a copy of the report, stated that he always thought both my girls were taking care of me. I didn't know there was a fight. He hadn't known. Through all of this, the emergency hearing, the guardianship, the withdrawals, the fake invoice, our father had largely been shielded from, or simply hadn't fully absorbed, the depth of the conflict happening around him and in significant part about his own money. Yvonne's attorney tried to argue that even if some transfers were questionable, they didn't rise to the level of requiring guardianship to be reassigned entirely, that corrective accounting and repayment could resolve the financial issues without stripping Yvonne of her role. The judge did not agree. The judge's ruling, delivered a little over 3 weeks after the full hearing concluded, did 3 things. First, it invalidated the March 9 power of attorney entirely, citing the medical chart timeline and the absence of any documented capacity evaluation, finding that Dad had not possessed the legal capacity to knowingly execute the document at the time it was signed. Second, it terminated Yvonne's guardianship and appointed a professional, court-supervised fiduciary, a neutral third party whose entire job is managing exactly these kinds of situations, to oversee Dad's finances going forward, at least until Dad's ongoing recovery and a follow-up capacity evaluation determined whether he could resume managing his own affairs independently, which his doctors, encouragingly, believed was a realistic possibility within another 6 to 12 months. Third, and this was the part that took the longest to actually resolve, the judge ordered a full forensic accounting of the guardianship period and referred the case to the county prosecutor's office for review of potential financial exploitation of a vulnerable adult, a felony-level charge in Ohio when the amount involved exceeds a certain threshold, which the $128,700 figure clearly did. I want to tell you that watching the ruling get delivered felt like triumph. It didn't, not really. It felt like relief mostly, and underneath the relief, a heavy, complicated grief for my father who'd been used at his most vulnerable. For my sister, who I still loved even as I sat there having just watched a judge formally document what she'd done. And for whatever version of our family existed before any of this, which I understood, sitting in that courtroom, was never fully coming back. One more question for you before we finish this one out. Do you think consequences like criminal referral are fair in situations like this, even between family, or does that cross a line? I've seen arguments both ways in the comments on stories like this, and I'm genuinely curious where you land. The prosecutor's office review took another 4 months. In the end, Yvonne and Marcus reached a negotiated agreement rather than going to trial. A restitution plan requiring full repayment of the $128,700 over 5 years, mandatory financial counseling. And because the prosecutor's office weighed both the harm and the absence of any prior record along with genuine, if late, cooperation once confronted with the evidence, a deferred prosecution arrangement rather than a felony conviction, contingent on completing the restitution plan without further violations. The hardest conversation in this entire ordeal didn't happen in a courtroom. It happened almost a year after the stroke in Dad's actual unrenovated kitchen, the three of us, me, Yvonne, and Dad, sitting around the same table we'd eaten dinner at as kids. Dad had asked for it. He'd been in family counseling sessions, arranged through his rehab program's social worker, and he told us he needed to say something to both of us at once while he still had the words for it. I don't fully understand everything that happened with the money, he said, slower than his old speech patterns but clear. I understand enough, and I need you both to hear this from me, not from lawyers. He looked at Yvonne first. What you did was wrong. I don't care how scared you and Marcus were about your house. You should have come to me. I would have helped you, Yvonne. I always would have helped you. You didn't have to take it. Yvonne cried in a way I hadn't seen from her since our mother's funeral. She apologized, not the careful, lawyer-reviewed language from her earlier court filings, but something rawer. She said she'd been ashamed, that Marcus had begged her not to tell anyone how bad their finances had gotten, that once the guardianship gave her access, the first transfer had felt like just borrowing, and then it had been easier to keep going than to stop and admit what she'd already done. Then Dad turned to me. And you, he said, I need you to know I never doubted you were there. Even when I couldn't talk right, even when things were foggy, I always knew you were there. I didn't need vindication from a judge as much as I needed that single sentence from my father, and I didn't fully understand how much weight I'd been carrying until I heard it and felt something in my chest finally loosen. Dad's medical recovery continued steadily over the following year. By month 14 post-stroke, his neurologist and a court-ordered independent capacity evaluator both confirmed he'd regained sufficient cognitive function to manage his own affairs, and the professional fiduciary arrangement was formally dissolved, restoring full control of his finances directly to him. A moment that felt, honestly, like the real ending of this story, more than any court ruling had. Dad chose, on his own, once he had full control back, to set up a modest but formal arrangement. A small monthly allowance for Yvonne and Marcus's household while their restitution payments continued, structured transparently through a document his own new attorney drew up, with clear terms everyone, including me, could see. He told me privately that he wasn't doing it because he'd forgotten what happened, but because he refused to let fear of it happening again turn him into someone who stopped trusting his own family entirely. I didn't always agree with that decision. There were nights, honestly, when it frustrated me, when it felt like Yvonne was still, in some quiet way, benefiting from what she'd done. But I came to understand that this was Dad's choice to make, about his own money and his own relationship with his own daughter, and that my role wasn't to control that outcome. It was simply to make sure it happened with full knowledge and full transparency this time, instead of secrecy and forged capacity. Yvonne and I are not close the way we once were. We speak mostly around family occasions, Dad's birthday, holidays, the kids' school events. There's a formality to it now that wasn't there when we were younger, a carefulness on both sides. I don't think that fully heals. I've made peace with that mostly. I've thought a lot, in the time since all of this resolved, about how close it came to going a completely different direction. About how, if Dayton Memorial hadn't maintained a digital visitor log system, if I hadn't thought to request it, if Tomas hadn't asked that one simple question in a hotel room the night after the hearing, the entire narrative of the abandoning sister might have simply stood uncontested as the official record of what happened during my father's illness. That's the part of this story that unsettles me most, even now. Not that my sister lied. People, under enough fear and pressure, sometimes do terrible, human, understandable things. What unsettles me is how easily a lie like that could have simply become the accepted truth, absorbed into family memory, into court records, into my own father's understanding of who had actually shown up for him, if the evidence hadn't existed, or if I hadn't had the resources and the stubbornness to go find it. I think about people who don't have an accountant husband to ask the right question, or the savings to hire an elder law attorney, or a hospital system organized enough to keep detailed digital logs. I think about how many quieter versions of this exact situation probably resolve very differently, with no forensic accounting, no guardian ad litem, no judge ever hearing anything but the more convincing liar's version of events. That thought has stayed with me longer than almost anything else from this whole year. Not a milestone birthday, Dad's 72nd, actually, the first birthday after his full capacity was restored. We kept it small. Me, Tomas, B, Yvonne, Marcus, the kids. Dad's kitchen, still unrenovated, still the same dated cabinets from the 80s, and somehow that detail, the kitchen that BrightPath Home Solutions was paid $9,400 to design and never touched, had become almost a private joke between me and Dad, something we could finally laugh about without it hurting. Maybe I'll actually renovate it myself, he said, cutting into a store-bought cake, with my own money that I'm actually managing. Nobody needed to say more than that. Yvonne laughed too, a little painfully, the kind of laugh that acknowledges a wound without reopening it further. I didn't give a toast that night. It wasn't that kind of gathering, but if I had, I think I would have said something like this. That showing up for someone quietly and consistently without needing anyone to witness it or believe it is still worth doing, even when, for a while, the loudest version of the story isn't the true one. Eventually, if you're patient and if you're willing to do the hard, unglamorous work of documenting the truth instead of just feeling wronged by its absence, the record tends to catch up to reality. If you're watching this and you're in the middle of something like what my family went through, a sibling rewriting the story of who showed up, a parent's vulnerability being used as an opportunity by someone you never expected, I want to leave you with the thing I wish someone had told me on that first, shaking drive home from the courtroom. Don't rely on memory or feelings to fight a false narrative. Rely on records. Visitor logs, bank statements, medical charts, timestamps, the kind of unglamorous, bureaucratic paperwork that feels tedious to chase down in the moment, but that doesn't lie, doesn't forget, and doesn't have a motive of its own. My sister's version of events was emotional and immediate and convincing in a courtroom for about 11 minutes. The truth took longer to assemble, and it was quieter, and it was boring in the way real evidence usually is. But it held. My father is 73 now, fully independent, still living in that same house with the same kitchen, still, as far as I can tell, choosing every single day to trust his family again despite everything. I don't know if I could be as generous as he's been. I'm still working on it. This story is fictional, created for entertainment and reflection, and any resemblance to real individuals or events is coincidental. If tonight's story taught me anything worth passing on, it's this. The truth doesn't always shout the loudest in the room. Sometimes it's sitting quietly in a hospital's filing system, waiting for someone to ask the right question.